enkantolo kodwa bekunamanye amacala esaphenywa kungakaqedwa ukuphenywa hayi ukuthi angakaqulwa noma angakafakwa enkantolo.
Okay. As the court, please, my lord, we don't want to interfere with my colleague's cross-examination, but we just want to get clarity. At the inception of her cross-examination, she mentioned that she's conducting cross-examination on behalf of accused number 2. Counsel for accused number 2 has already conducted cross-examination. I suppose it might be just a slip of the tongue that was meant to mean on behalf of accused number 5. Because no two counsel can cross-examine a witness for the same accused.
Yes, Ms. Memshorul.
Yes, the court pleases, my lord. I submit, my lord, with the due respect that I am entitled to cross-examine the witness on the evidence that he testified on.
On behalf of?
On behalf of accused number 2, as I'm cross-examining on.
Have you read the case of by Hutzenbeck, State versus who's that gentleman? The Dr. Death. What's his name, by the way?
Basson.
State versus Basson. Have you read that case?
No, my lord.
It says exactly what your learned colleague is telling you. That in one case, you cannot have more than one counsel cross-examining on behalf of a person who is said to be accused so and so. Only one person can do it at a time in the same trial.
My lord, if the court is of the view that I should not do cross-examination to this witness, I won't have any questions.
No, it's not the court. You know what? Just go and fetch that case of State versus Sonnet. Basson, State versus Basson. It's by Hutzenbeck. Let's just pause and read it because I'm now being accused that I am denying you the opportunity to cross-examine. It's not me.
No, it's not the accusation, my lord. I respect the court.
Why don't you check it? You've got a computer there, Mr. Baloi.
My lord, we don't even need to go there.
No, we have to.
That's a very long judgment, madam.
Hello?
It's a very long judgment.
No. We just
The whole afternoon and the whole
we just extrapolate the right. Are you aware of it?
Yes, I'm aware.
Am I correct in saying it says that?
Yes, madam.
Unless there was an exception which was made by Judge Hutzenbeck because they were busy with a case which was intricate and it was voluminous.
Yes.
And he said, on the basis of that, they will give an indulgence to render an exception. But generally, once a counsel is being is cross-examining a particular person, you see what Mr. Msholo says? He says he's cross-examining on behalf of accused number 2. That's what you are saying, is that not so? Hello?
My lord, if the court says I should not cross-examine, I will proceed.
You keep saying the court says. I'm saying the law says.
As the court basis.
So let's read the law. But you know what? If you phrase it some other way, it could perhaps be permissible. But if you're saying you're crossing on behalf of accused number 2, when Mr. Ngomezulu already said that, and he knows Mr. Ngomezulu, I told him that he can't do it because Mr. Ramosipidi had already done so, you remember? But I said, because we are coming into the case for an exigency of fairness, I'm going to relax that rule. And I can even do it now, but people must understand that it is not I saying that, it's the law.
As the court basis.
Just read that. In the meantime, okay, fine.
Ummeli bekathi ubuza imibuzo ebuzela ummangalelwa wesibili manje kunomthetho owakhishwa yinkantolo, hayi ujaji Muphatheki, inkantolo ukuthi iye yathi akunammeli ongabuza imibuzo ebuzela omunye ummangalelwa onommeli, njengoba ukuthi ummangalelwa wesibini unommeli. Manje njengoba usisi esukumela phayana uzakwethu sayofuna lowo mthetho ukuze uzofundwa naye enkantolo ukuchazisela ummeli. Uyawazi naye uthi uyawazi uma ingabe inkantolo isho njalo uthi ngeke abe nemibuzo, kodwa usalindwe loyo mthetho ukuze kungabi ingathi ujaji akafuni ukuthi ummeli aqhubeke.
Yeah, incidentally, Hudson Beck was a judge in this division. He retired somewhere 2000, I think 2004, somewhere there. And he was actually the most senior judge at that stage by experience, although he was not the judge president, and neither was he the deputy judge president, if I recall. Mr. Baloyi, you don't,
We'll check that. We can proceed on the basis that Advocate
you don't get
Mshalala
that decision.
we do it's
So what's your problem?
it's referred to in several. We do have the decision, my lord, but we're just looking for the paragraph. There are about 4 references to the case, and we're still searching for that specific paragraph, my lord. But we just thought that to save time,
No. You can't save time by not doing the right thing.
because we'll look for it.
Mr. Mnisi, you can't find a decision. On the head note,
There are 2 judgments, one from Judge Hudson Beck here and the one from Constitutional Court. I think
Yeah,
the
yeah,
one that
no.
normally comes in 2.
do you have both of them?
I've got the one that is from the Constitutional Court.
Yeah, quote it,
But
quote it.
then it confirms what the
Hudson Beck said.
judge said.
That's it. Ms. Mshololo is not aware of those judgments. Mr. Mgomezi, you didn't read that judgment after I quoted it for you. Dr. Hudson Beck.
We read it, my lord. State versus voter person.
Voter Basson, yeah.
Yes.
But in fact, that judgment goes further than what I have just said, because I am saying the general principle is that 2 counsels in the same matter cannot conduct a cross-examination of a state witness on behalf of a client. Here, the client is represented by Mr. Ngomezu. But the ratio in that case, it says two counsels acting for one client can't do that. They've got to divide themselves. But here, as I say, there is a slight nuance in the sense that Okay, I've got the judgment here. S versus Basson 2001-2 SACR 537T. This matter was heard on the 30th of July 2001 by Hudson-Beck R. The head note reads like this. Fly note, trial, dash witnesses, dash cross-examination, dash of accused by more than one state advocate, dash long and complicated case concerning two separate groups of charges, cross-examination by two state advocates, allowed on certain conditions. Head note, during the trial of a long and complicated case, the state applied before the accused was to testify for permission for the accused to be examined, cross-examined by two state advocates. The state's legal team consisted of two groups, two of the advocates handling the charges of fraud against the accused and the other two advocates handling the other charges. Whilst one group was busy with its part of the evidence, the other state advocates were not present in court. The state contended that there were in effect two separate cases before the court and that the case was an extraordinary one in which a mass of evidence had been laid. The court referred to the rule of practice which prohibits the cross-examination of a witness by more than one legal representative of a particular litigant, but held that there were some exceptions to the rule where the courts had held that they had a discretion to allow a deviation from the rule. The court was of the opinion that although the case had two legs, there was a measure of overlap. A refusal of the application would prolong the case. The court accordingly upheld the application on the following conditions. One, that the leaders of the two groups of state advocates be permitted to pose any further questions after they had finished cross-examination and his colleague had begun his part of the cross-examination. The advocates had to determine who would first cross-examine overlapping evidence, and one advocate who first cross-examined on such an aspect completed his cross-examination on that aspect, and no further examination would be allowed by the other advocate of the aspect unless substantial reasons could be provided for deviating from the rule. Actually, the gravamen of this rule of practice is to avoid a repetition of cross-examination. Like for instance, the question Ms. Msololo has asked you, it was asked.
It was asked and answered by me.
I know. I can repeat it. It was asked. Now we are being asked that question for the second time, in other words. But you know what? I'll bend the rule, do it again. You can cross-examine, but you must know that that law says that. So I'll take it for granted that maybe you have some information or facts which you predicate your cross-examination on. Because remember, at this stage, we are on a trial within a trial, the admissibility of a trial within a trial. And just for another precept, just a moment. There is a case of, and it's not me saying that, it's the law books. There's a case regarding admissibility. When issue of admissibility is to be determined, the duty of the presiding officer is to keep inadmissible evidence out not to listen passively as the record is turned into a papery sum of appropriate to some situation. A papery sum of evidence, Frequent practice of administering evidence provisionally, though appropriate to some situation, often works, unfortunately. The case, you can take the citation. The case is State versus Rama Valley, 1996, 1, SACR 639 AD. The judgment was written by Schultz. He was sitting with her and others. Okay. I said you can continue if you want to.
The court is.
But the proviso obviously is that if the question has been asked and answered, this judgment says I mustn't allow it. Okay.
As the court business. Brigadier, is it correct that under the Nongoma case 136, sorry, not 136, 163/10 of 2018, which was being investigated, at the time when accused number 2 was arrested, you were not in possession, or you did not have a warrant of arrest against accused number 2?
I've answered it, my lord. On my answer, dealt with it in evidence in chief and under cross-examination.
Yeah, that question was asked. And I think you said the person who arrested the gentleman, accused number 2, as a result of the investigations pertaining to the murder in Nongoma, was Sergeant Mohale.
Correct. In the company of Sergeant Mapena.
That's it. So that question has been answered.
Thank you, my lord.
Inkantolo iwufundile lo yamthetho nangokho inkantolo iwufundile ithe kulungile ummeli angase aqhubeke nangokho lo yamthetho uthi bekwamele kungavunyelwa ukuthi abuze imibuzo njengoba ummeli wakhe sekawubuzile. Uma ebuza manje ubuza ukuthi iqiniso ukuthi ngalesikhathi niyobopha ummangalelo wesibini nanikade ningenayo incwadi egunyaza ukuthi ummangalelo wesibini aboshwe. Yaphendula uBrigadier Ruth besisenguphendulile lo mbuzo. Benguphendule ngithe
Have we already arrived? Or is our journey just beginning? Be the next generation of joy.
ayikho incwadi egunyaza ukuboshwa kommangalelo wesibini uthi uBrigadier nalombuzo sengawuphendula.
Sorry, just to be fair to Ms. Mshololo, were you in court when the Brigadier testified when asked questions by Mr. Mgumezulu pertaining to the J50s, ne?
Yes, madam.
That the J50s were issued for each and every accused.
Correct, madam.
And those are warrants of arrest which enable this brigadier to take these guys to court after arresting them. I'm just saying, I listen. So there were 5 actually warrants of arrest. And you are putting it to him that up to today, there was no warrant of arrest issued for accused number 2. So the evidence shows that, and I'm not giving evidence because I'm being accused, I interfere, I give evidence. The evidence which I listened to by this witness is to that effect that a warrant of arrest was issued by him. And that you applied for the warrant of arrest on application to a magistrate in Boksburg.
Correct, madam.
Yeah.
My lord, maybe I referred to case 636, which is the case that we are dealing with here. But my question was...
Okay, fine.
My question was intending to ask in respect of case Nongoma case 136,
Okay, fine.
my lord. Not the one that, Brigadier, I'm not referring to the one that we are currently busy with. which is false.
Yes, my lord, but even that, the question was put to me by Advocate Ngomi Zulu about exactly that, the status of Nongoma 163 of 10/2018, and I've answered. It was a similar question, my lord.
Okay.
Yebo mina ngawuphendula umbuzo ngalo leliya cala laseNongoma ebelibuzwe umbuzo bobuzwe ummeli uMngomezulu.
And also, under the Nongoma case 289/11/2012, which is the docket that was supplied to us. Also in that case, there was no warrant of arrest at the time when accused number 2 was arrested until today.
Yes, there wasn't, my lord.
Ngelana namhlanje kulelinye icala lesibini kuleli dokodo enasinika lona ufikela nanamuhla akukabi nencwadi egunyaza ukuboshwa kumangalelo wesibini uthi yebo ayizange bekhona leyo ncwadi.
Same thing with the third case, which is Foster's case number 88/06/2012.
Yes, my lord.
Nale ncwadi nale cala leli laseFosloras nalo alinayo incwadi egunyaza ukuboshwa kombangalelo wesibini uthi yebo.
Okay. It's fine. Let's move on to the statement that was made before Colonel Mboto. Colonel Mboto testified about the statement that he took on behalf of accused number 1. Are you following?
I'm listening, my lord.
Yes. My question there is that looking at the time, or maybe if I can just remind you, the statement was taken on the 30th of May 2020 at 21:45.
Correct?
Yes.
That's a starting time, my lord.
Statement sithathwe nge-30 zika May 2020 ngo-10:15.
Okay. Am I correct also to say it is alleged that the accused indicated that he wanted to make the statement during the day?
Alleged by whom, my lord, that he wants to make a confession during the day? I'm not aware of it.
Okay.
Iqiniso nawo ukuthi bekuthiwe kunamahebezi abe athe ummangalelwa bekathe yena angathanda ukugunyuluka emini uthi ubrigadier ubani obekade ena ekhuluma lelo ndaba.
Before the statement was taken by Colonel Mboto, it would have came to your attention that the accused had indicated to make the statement.
Yes, my lord, and I testified about this.
Yes.
Ngaphambi kokuthi akhulume noColonel Mboto besese wena unolwazi lokuthi ummangalelwa bekathe ufuna ukukhuluma uthi yebo besese ngiphane nangobufakazi balokho.
And at what time of the day did you become aware that accused wanted to make the statement?
My lord, I testify about this. I even disclosed my diary, which indicates the time when I was informed, leading up to Foster's meeting accused number 1 at Foster's outside the police station. I testified about this in evidence in chief and under cross-examination, right up to the time this confession was taken by Colonel Mboto.
Wazenini wena ukuthi ummangalelwa ubekade efuna ukuwenza istatement uthi ubrigadier mina besesengichazile lokho Nkosi yenkantolo kusukela esikhathini ummangalelwa ngizobe ngaziswa kufikela aze ayenza leso statement besesengichazile uma ngiqala ngobufakazi bami nanoma ngihlonywa ngemibuzo ngiye ngachaza lokho.
Why, according to your knowledge, why accused number 1 was not taken to the magistrate to make the statement?
My lord, it was Saturday. If you look at the date of the 30th of May, it was Saturday. I met him, I think, around 1900 hours. I've testified about this. I'm not sure if you can find a magistrate around that time. So that's the first part. But second, my lord, commissioned officers carries the same powers as justice of peace insofar as taking the confessions. That is the essence of it, my lord.
Kungani ummangalelwa yokuqala yena angazange ayisiwe kumantshi ukuze ayenze statement sakhe uthi ubrigadier uma iphendula bekade kungumgqibelo uyakhumbula ukuthi wahlangana nommangalelwa ngabo 7 ntambama la ukuthi akekho umantshi osebenzayo ngaleso sikhathi kodwa bonke ukuthi banegunya lokuthatha istatement nabo bayafana banegunya elifana nabo mantshi.
Thank you. If if it is correct, then the accused had indicated freely and voluntarily that he wants to make the statement, why was it necessary that it is done at night? Why didn't you wait for the following day for the accused's statement to be taken?
No, but my lord, where is that regulated? There's someone who wants to confess in a complex manner that I'm seized with. He's aware of his constitutional rights. He wants to make this confession freely and voluntarily, and one makes an attempt to find an independent person, and that person is found. Why would you want to delay the checking of that? I'm not aware of a provision that says you must wait until the morning.
Manje uma ingabe ummangalelwa yena wayekade efuna ukukhuluma kanjalo kungani ke kuye kwaphoqeleka ukuthi ayenze istatement sakhe ebusuku? Uthi ke ubrigadier mina anginawo umthetho ongiwaziyo othi umuntu mayefuna ukwenza istatement kwamele kulindwe ilanga elizayo ngoba bekade efuna ukwenza istatement kwicala elibucayi. Manje kungani kwamele simlinde ukuthi siyenzwe ilanga elilandelelayo ngoba lo muntu ufuna ukukhuluma manje kungani bekwamele simele ilanga elilandelelayo? Angiwazi umthetho osho njalo.
And that was done, sorry, madam. That was done, sorry, counsel, to speak over you. It was in the interest of justice because it cut both ways, my lord. It's also the interest of justice that when such evidence comes to you, you must collect it as professionally and as adequate as you can to build the state's case, because that's what I was assigned with this matter for.
Futhi ke lokho ngikwenze mina ngibheke ubulungiswa ngoba umthetho uthi kwamele kubhekwe ubulungiswa uma kusetshenzwa ngamacala.
And the accused at that time, I'm talking about the time when the statement was made, which is 2145 minutes up to 12 o'clock when it was completed, allegedly. The accused was supposed to have been sleeping by that time, resting.
My lord, I don't know how counsel knows the pattern of, I don't know the pattern, maybe I should answer this way. I don't know the sleeping pattern of accused number one.
Lesi statement siyenzwe ebusuku ngo
when you became aware that accused number one wanted to make the statement, were you with the accused or you were informed by someone else?
My lord, I testified about this. I was cross-examined about it as well. I was informed by Sergeant Mukula, that's what I indicated,
Okay.
an arrangement then we made for us to meet at Phosphorus police station. I was informed. I testified about this and I was cross-examined by Mr. Gomez about it.
ngalesikhathi ummangalelwa efuna ukukhuluma wawukade unaye na uthi Nkosi yenkantolo bese sengichazile ngalesikhathi ngibuzwa ubaba uMngomezulu ukuthi mina
Date, accused number two, after his rights had been explained, he indicated that he wanted to make the statement.
Well, to me, yes, it's recorded, my lord. It's recorded in my diary, and I testified about this, and I gave the copy of my diary to counsel, including Ms. Advocate Mshololo, and they read the original, which I still have. It's indicated that I was informed at a specific time, what time I met the accused, the issues of rights are indicated there in the diary, and I've made the copies to the defense available.
ukhona na la kubhalwe khona ukuthi ngesikhathi esithize ummangalelwa wesibini yena ubekade ufuna ukwenza istatement na uthi yebo sengishilo lokho futhi ngibuziwe na ngakho imibuzo ngishilo ukuthi ngikubhale kwi-diary yami i-diary ukuthi ngiyenganikeza umshushisi wanika nabameli bonke naye uMamshololo unayo.
Is there a space wherein accused number two signed in that entry that you made? Signed that he is indicating to you that he wants to make the statement.
My lord, I'm not aware of that provision. I've never seen an accused that must sign in the police diary that he wants to make a statement. I've never come across such, my lord, with due respect.
Kukhona la ukuthi ummangalelwa usayine khona kwi-diary yakho ukuthi yena wayekade vele ukwenza efuna ukwenza leso statement.
Examining interchangeably. Here she said accused number one. Now she's now on number two.
My lord, the statement that was made to Colonel Mboto is for accused number one.
Yeah, I'm just answering your learned colleague.
It's for accused number 1, the statement that was made to Colonel Holt.
Yes, go on.
Thank you, Madam. Whether you know the procedure or know the procedure, I just wanted to know that there is no way wherein he acknowledged or he signed the entry that you made in your diary.
No, but this witness says there is no such procedure. So if you know the procedure, put it to him so that we make progress. That
As-
the procedure dictates, or the law dictates that.
As the court pleases, my lord. Brigadier, is it not the procedure that when you are conducting interview with the suspect, you will have a pro forma in front of you, wherein when you follow that pro forma, I think we are familiar with that, you will explain the allegations, the constitutional rights, and then you will record the response given by the accused after the allegations had been explained to him.
My Lord, counsel is referring to a warning statement. That's what you're referring to. There's a difference when you meet someone on the street, whether you're executing the warrant of arrest. There's never been a situation, my Lord, when you're carrying a warrant of arrest, simultaneously you will carry the interview form and say, this is the warrant of arrest, I'm arresting you, now I must take you through the warning statement. It doesn't work like that. That's not how it's supposed to be done. You meet the person, first is the arrest, the constitutional right in terms of what he is entitled to, you deal with that part. Subsequently, when the detention and the time to prepare the person for court, that form kicks in. But you can never make an arrest and simultaneously at the time when you're making an arrest, take the person through the warning statement. It's not doable, my lord.
Uthi ke ummeli incwadi le eyemibuzo ube kade unayo njengoba wawukade uhlangana nomangalo lesibili ubrigadier uthi ayikaze yenzeka empilweni soloko yena kuyiphoyisa la ukuthi uphethe incwadi egunyaza ukuboshwa kwamsolo bese kuba nale yemibuzo uthi cha ayenzeki leyo kuyaye kube nokuthi umuntu kube nale ncwadi egunyaza ukuboshwa kwakhe bese atshelwa amalungelo wakhe kodwa leyo yokuthi yokuhlonya imibuzo kaningi akusincwadi ukuthi unobani ukuthi bayiphathe isikhulukazi uma behlangana nomuntu emgaqweni.
I put it to you, Brigadier, that is this procedure, that is the standing procedure by SAPS that whenever you are conducting an interview, or not necessarily that you, whenever an interview is being conducted with the suspect, immediately after he has been arrested, when there is interview that is conducted, it must be recorded. And that form is assisting to ensure that the constitutional right of that persons are not infringed.
No, but I disagree, my lord. Counsel is talking about the product that is at a later stage. It's well known, my lord, that people get arrested with or without the warrant, even by uniformed members on the street. Those members who arrest them on the street, they don't carry warning statements. They will arrest them on the allegation that is before them, or the evidence that is before them, take them through the holding cells where they are processed on the ACP 14, 14A chart and kept there. Then the investigating officer will come either on that day or the following day, then take them through the warning statement. But by the time the warning statement kicks in, police have already dealt with them in terms of the arrest, and question may have arisen. They would have even maybe followed alibis in terms of what they are saying or followed certain information. So that is not correct, that when you arrest a person, that form must simultaneously kick in. That's not how it's done.
Ukuthi ummeli ke mina ngiyacebisa ngiyakwazisa ukuthi umthetho wesiphoyisa ukuthi uma niyobopha umuntu incwadi leyo kwamele ibe khona uthi cha akwenzeki futhi namaphoyisa nje uma bayobopha umuntu bangaba nayo incwadi egunyaza ukuboshwa kwakhe kodwa le eyemibuzo akuvamisanga ukuthi babe nayo ngoba bafika bambophe lo muntu loyo bese uyabuzwa ke imibuzo aziswe namalungelo wakhe. Leyo ncwadi leyo inokaningi iyaye igcwaliswe ngemuva uma seyikuthi lo muntu loyo kuhlelwe phansi naye kodwa uma kusayiwa kuye akusuka ukuthi kuvamisile ukuthi ibe khona leyo ncwadi.
Furthermore, my lord, I can just add, sorry, counsel, that even when the person is arrested for the first time, his or her constitutional rights are explained to her verbally. But the formality of those constitutional rights, my lord, kicks in at the holding cells when the SAP 14A is completed. So it doesn't mean that when the 14A is completed at the holding cell, it is the first time the person has been made aware of his rights. When he's arrested, it's a procedure that he must be warned according to his constitutional rights, but no form. No one goes around carrying the SAP 14 form, my lord. Same with the warning statement. That is done at a later stage.
Futhi ke kuyayenzeka nokuthi umuntu acebiswe ngamalungelo wakhe uma eboshwa ngaphandle emgaqweni bese ithi uma esesemaseleni uma ezocebiswa futhi ngamalungelo wakhe bese kulabo ugcwaliswa lencwadi le alikho iphoyisa elihamba liphethe incwadi emgaqweni.
Let's leave that for the argument, Brigadier. Let's move forward. Is it also correct that you asked Constable Monareng of Metropolis Ekurhuleni to accompany the team that was transporting accused number 1?
I've dealt with
On the 30th day of May, when specifically he was taken to Cannonboard.
Yes, I've dealt with this, my lord.
Okay.
Manje iqiniso na ukuthi wena Brigadier uye wacela njengoba bekukade kuyiwa ku Cannonboard uthi bese senguphendulile
To give protection to the team. By team, I mean the SAPS members. So as Metro, he was asked to give escort to the team. That's why I'm asking you to clarify for me that what is it exactly that he was asked to do at that time when accused number 1 was taken to Cannonboard.
My lord, I dealt with it. I was cross-examined about it. I testified about it insofar as the evidence in chief is concerned. I dealt with it, that I phoned him, we met, I handed the accused to him, explained, I've dealt with it, my lord. And questions were put to me and I've answered.
Yeah, can you answer my question? Because I want to know what is it that you ask him to do,
But I've
specifically,
answered,
Constable Monareng.
I've answered, Counsel.
Are you refusing to answer the question? We are a police officer. We are a member of the police officer. You are bound to repeat this answer and answer my question. What is it that you ask specifically other than what he said in this court?
No, my lord, with greatest respect to Counsel, I'll repeat it again. I've said, I asked Constable Monareng to assist with the escort of accused number 1 from the provincial office to Cannonboard. They were not involved in that regard. Subsequent to the completion of the confession, I further asked him to escort the investigating officer insofar as the matter of accused number 1 is concerned, Sergeant Mukola, with what she needed to do up to the time that they were detained. That is insofar as my activities with Constable Monareng. I testified about this in evidence in chief, and I think I dealt with it extensively also during the cross-examination.